The Supreme Court smacked down the Trump administration's efforts to summarily cut off aid around the world. Hooray! The Supreme Court decided that Congress still matters. And that's great, the celebration by most commentators is warranted, but I'm sorry to tell you there are some very, very dark clouds lurking in the background. And this decision's tepid defense of the rule of law could spell disaster in the future. In a very brief 5-4 unsigned opinion, the Supreme Court upheld the lower court's order for the administration to pay out on its debts. Yes, if you're keeping score at home, that's 4 votes in favor of basically dictatorship. But at least Justice Amy Coney Barrett sided with Justice Roberts and the liberals in defense of the law, I guess, which caused all kinds of right-wing infighting, so that's nice. But it may be too early to celebrate because the Supreme Court's willingness to even consider overruling a lower court's temporary restraining order was itself a strange and ominous sign. And more troublingly, 4 members of the Supreme Court signaled that they didn't think the courts even have the authority to consider this case because this case is a violation of sovereign immunity. But what does this all mean, and how did we get here? Well, a week ago, we talked about the AIDS Vaccine Advocacy Coalition versus the Department of State case, but that feels like a lifetime ago, so let's do a quick refresher to delve into the aspects of this case. On January 20th, 2025, President Trump issued an executive order titled Reevaluating and Realigning United States Foreign Aid, which directed an immediate freeze in United States foreign development assistance. This halted a broad array of foreign aid programs, many of which were life-saving campaigns aimed at alleviating hunger and providing essential medical care. OMB then issued a memorandum detailing instructions for the fulfillment of Trump's executive orders on grant programs, including the Foreign Aid Executive Order. In its memorandum, OMB ordered other agencies to pause the disbursement of all federal financial assistance, including foreign aid. Soon afterward, 2 separate courts issued orders forbidding the Trump administration from continuing this funding freeze. The administration took that court order under advisement and continued to do what it wanted to do, withholding funding on a wide variety of grants, contracts, and awards, including 800 USAID awards and contracts. The administration conducted these funding freezes with its usual level of incompetence. One of the plaintiffs in this case noted it received, quote, a flurry of stop work orders, often without any indication of what awards they were in reference to. The stop work orders contained vague and contradictory statements. Some letters indicated the award was being terminated because it no longer effectuated agency priorities. Others claim that the award termination wasn't because of any actions of the organization and was instead being ordered so that the new administration could have time to review the awards. Chaos ensued. Organizations around the world were forced to shut their offices, lay off their staff, and turn away people the United States had pledged to help. Millions of people around the world were affected, and humanitarian operations for refugees in places like Syria were abruptly stopped. Soup kitchens in Khartoum were closed, and clinical trials for life-saving children's tuberculosis treatments in Uganda were halted. So on February 10th, a lawsuit was filed for a variety of aid organizations, including an AIDS research organization, an organization that promotes journalism about corruption-related issues, an organization that protects refugees and asylum seekers, and an organization representing small businesses in this sector. These organizations laid out a list of heart-wrenching harms in their filings and pleaded for a temporary restraining order from the court. And as we've talked about, this is an unusual and challenging ask. Now, lately we've spent a lot of time talking about temporary restraining orders, or TROs. And that is weird because TROs are an extraordinary remedy and only appropriate in cases where the imminent harm justifies immediate court action and the loosening of usual procedural requirements. So it's remarkable that so many TROs have been granted against the Trump administration, and all in less than 2 months. And in the AIDS Vaccine Advocacy Coalition case, the plaintiffs argued that a TRO was warranted, though, because the plaintiffs are likely to succeed on the merits of the case, there's irreparable harm, the balance of the equities tips in their favor, and the injunction is in the public interest. And plaintiffs managed to make their case on all counts to Judge Ali in the DC District Court. In their filings and in hearings, the plaintiffs laid out a long list of irreparable harms, including the disruption of clinical trials for HIV prevention medication, the shuttering of program offices that protect refugees and asylees, the closure of small businesses that provide aid, the disruption of maternal and child health programs, the end of medical services for adolescents and students, and a freeze on time-sensitive anti-malaria campaigns. And the administration's attorneys were, at least, willing to concede that this parade of horribles contained irreparable harms. They argued, though, that the plaintiffs were unlikely to succeed on the merits of the case. The court disagreed, finding that the plaintiffs were likely to succeed on the merits, and the court agreed that a blanket freeze on all contracts was likely a violation of the Administrative Procedure Act because it was arbitrary and capricious, stating that, quote, there has been no explanation offered in the record, let alone a satisfactory explanation, including a rational connection between the facts found and the choice made, as to why reviewing programs, many long-standing and taking place pursuant to contractual terms, required an immediate and wholesale suspension of appropriated foreign aid. The defendants, for their part, tried to claim that this wasn't actually an agency action, it was a presidential action and was thus not subject to the Administrative Procedure Act, which governs agency actions. But the court wasn't buying it, finding that the defendant's argument, quote, would allow the president and agencies to simply reframe agency action as orders or directives originating from the president to avoid APA review. And that makes perfect sense because on some level, all directives come from the president, and if that's all it takes to avoid the APA is meaningless. But Judge Ali declined to give the plaintiffs the full relief that they were asking for, choosing instead to grant a narrow order which temporarily enjoined the government from freezing funds or issuing stop work orders on programs that were already in existence as of January 19, 2025. The court, however, allowed the government to stop funding for individual contracts if it was part of enforcing the pre-existing terms of their contracts, including expirations, modifications, and terminations. And the administration took full advantage of that loophole. Now, if you're going to disregard the order of a federal court judge, you'll want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying the your information might have been leaked, or dealing with a workers' comp or social security issue, we can help represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. In the government's February 18th briefing, the defendants unabashedly stated that, quote, thus far that analysis has confirmed that at least substantially all of the terminations, suspensions, and stop work orders issued on USAID contracts, grants, and cooperative agreements were allowed by the terms of those instruments or terms implicitly incorporated into those instruments. That was not only wrong, but it would have been impossible for them to make that determination on hundreds or thousands of contracts in that time frame. So in response to the revelation the defendants were still effectively freezing nearly all funding, the plaintiffs filed a motion for contempt. The court was apparently unimpressed with the defendant's failure to comply. Judge Ali declined to find the defendants in contempt, but he did reiterate that the defendants needed to end the blanket freeze on funding. But for some reason, this was still not clear enough direction for the defendants, who asked the court to clarify its order. On February 22nd, Judge Ali replied to defendants' motion for clarification, stating that, quote, the line here is unambiguous. Defendants cannot continue to suspend programs or disbursements based on the blanket suspension that was temporarily enjoined. And defendants cannot simply come up with a new post hoc rationalization in an attempt to justify the action that was temporarily enjoined and is likely arbitrary and capricious for what it failed to consider. Judge Ali reiterated that particular contracts could be paused, but only if there was an individual evaluation of that specific contract. A blanket freeze, however, would be a violation of his order. And to underscore his point that he'd already been clear enough, Judge Ali quoted from his own prior order. And defendants, intent on continuing the blanket freeze on life-saving congressionally appropriated foreign aid funds, filed an interlocutory appeal to the D.C. Circuit Court and asked Judge Ali to stay his order in the meantime, complaining that, quote, court's order requires defendants to disburse nearly $2 billion by 11:59 p.m. tomorrow. And Judge Ali, who was apparently very good at suffering fools, denied the motion for a stay and reminded the defendants he'd already granted them a fair amount of flexibility, and it appears as though they haven't done anything to comply with his order. He was unmoved by the defendants' arguments that they hadn't had enough time to comply, pointing out that they had never actually asked for more time, and after reciting a laundry list of insufficiencies in the defendants' arguments, he denied the motion for a stay pending their appeal. But that appeal itself is also procedurally weird. Now, fun fact about TROs, they usually aren't appealable. That's because they are extraordinary and temporary relief. But the defendants tried a sleight of hand. They claimed they weren't appealing the judge's TRO itself, they were appealing his subsequent orders to enforce the TRO. Well, the Court of Appeals could not be tricked. In a very brief 2-page ruling, Judges Pillard, Pinn, and Garcia held that TROs generally aren't appealable, and neither are any later issued orders seeking to enforce an unappealable TRO. And so the defendants, still intent on withholding life-saving congressionally appropriated foreign aid, appealed their case to the Supreme Court of the United States, asking the court to vacate Judge Ali's order. Now, this was also a procedural anomaly because, again, TROs are usually not appealable. So all the Supreme Court needed to do here, and arguably should have done here, was nothing. Nothing would have been the ordinary thing to do. Instead, on February 26th, the Supreme Court took the extraordinary step of granting the defendants a stay so the Supreme Court could consider the case. Now, if you go to McDonald's and ask for a tire change, the answer should not be, well, think about it. But that's what happened here. Then, on March 5th, the court issued a 1-paragraph decision holding that because the deadline for the original TRO had passed, and because the parties are in the midst of briefing for a preliminary injunction in the district court, the stay would be vacated. In other words, that the original TRO would be in effect. But the court also instructed Judge Ali to, quote, clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. Now, let's be clear, this was a victory for the plaintiffs. The TRO will go into effect in some respect. But the TRO had already been on the books for 3 weeks and the government had done nothing to comply. And the court had issued 4 different orders ordering enforcement of the TRO. So it's not a great sign that the Supreme Court said, issue yet another order, but be more favorable to the government this time. But worse, that very brief ruling was followed by a fiery 7-page dissent authored by Justice Alito, joined by Justices Thomas, Gorsuch, and Kavanaugh. Now, by definition, a dissent does not carry the force of law, but what's in this dissent has a lot of bad signs for the rule of law. In a memorable opening salvo, Justice Alito wrote, quote, "Does a single district court judge who likely lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned." I mean, technically, yes, that is one way that you can summarize a court forcing the government to comply with the Article 1 and Article 3 obligations of the Constitution. It's a summary that belongs more on Fox News than in the pages of something issued from the Supreme Court, but here we are. Alito referred to Judge Ali's order as a lawless act of judicial hubris and said that Judge Ali had wrongly brushed aside and shrugged off the government's argument that sovereign immunity barred this enforcement order. He argued that by undoing the stay, the majority of the court had abrogated its duty to ensure that the power entrusted to federal judges by the Constitution is not abused. And in what is likely to be a common theme throughout the next 4 years, Justice Alito bemoaned the nationwide injunction in this context, though he loves it when it comes to restricting anything related to abortion. And Justice Alito argued that a TRO wasn't the right mechanism for all this, where vast sums of money would, as he put it, probably be lost forever. Weird way to say that the government is spending money on something it chose to spend its money on. But instead, the DC District Court ought to have taken the steps to order a preliminary injunction, which is an appealable order. The Court of Appeals should have vacated the District Court's, quote, erroneous order. Justice Alito also disagreed strongly with Judge Ali about which party was likely to prevail on the merits of this case. Alito wrote that the government would likely succeed in its argument that sovereign immunity deprives the district court of having jurisdiction over this matter at all, because sovereign immunity generally bars monetary suits against the government. Now, because the majority's response was so brief, they didn't delve into any of this, but there's good reason to believe that Justice Alito was mistaken on this point. Alito is correct that generally sovereign immunity bars lawsuits against the government. In particular, there's case law that bars monetary suits, but the government can waive that immunity, and it has done so in the Administrative Procedure Act, which expressly allows plaintiffs to sue the government for monetary relief. Alito argues that even the APA's waiver doesn't apply here because the relief Judge Ali granted would result in the government paying out billions of dollars. But Alito is confusing the plaintiff's request that the court order the government to honor its contracts with a demand for monetary damages. The plaintiffs in this case are not asking for monetary damages, and Judge Ali did not grant them in the traditional sense. Instead, he said the money at issue would be paid out as the natural result of the ordered action, the unfreezing of the contracts. That's an important distinction and would fit under the APA's waiver, allowing plaintiffs to file suit and seek unfreezing of the contracts. It's also important to note, as Judge Ali did after the case had been appealed, that defendants didn't really argue the sovereign immunity angle in their earlier filings. Alito is arguing it for them, but it was never really briefed on the district court level. Still, Judge Ali pointed out that he didn't think that this would be a strong argument or change his opinion about the plaintiff's likelihood to succeed on the merits. Alito also argued the district court's remedy was too broad because it had ordered the government to honor all of its contracts, not just the contracts it had with the plaintiffs. Now, it's impossible to know what the majority would think about this because it wasn't included in their one-paragraph opinion, but plaintiffs point out in their own briefings that what they were asking wasn't overbroad. What they demanded was merely the restoration of the status quo in which the United States government honored its contractual obligations. And this is the real crux of the case. If the government wanted to conduct an audit of all of its contracts, there's a way to do that. They could have reviewed each contract and then ended the ones that showed signs of fraud or abuse. That's what would have happened in a normal world. Instead, they put a blanket freeze on all contracts, ostensibly so they could conduct a review, but that's a review that they didn't or weren't conducting. And that's an extraordinary action that justifies Judge Ali's grant of extraordinary relief. But Justice Alito concluded his dissent with a parting shot at the, quote, self-aggrandizement of the district court and Judge Ali's hubris in ordering the Trump administration to pay out on government contracts. Justice Alito sees a constitutional crisis in the situation, and plaintiffs also see a constitutional crisis, but they're clearly seeing different crises. Now, where plaintiffs believe this is a question of separation of powers between Congress and the president, Justice Alito instead believes that this is a question of separation of powers between a lowly district court judge and the president. Now, we've discussed this before. The president doesn't have the authority to direct the disbursement of taxpayer funds. Article 1 of the Constitution, only Congress has that authority. And Congress has already designated these funds for foreign aid. For the president to step in and overrule Congress's spending choices, that's an extraordinary overstep and a violation of basic separation of powers. Now, we pointed out that the separation of powers issues will put this country into a constitutional crisis, but we might need to make that constitutional crises plural because there are multiple constitutional issues here. First, as we've mentioned before, will the president obey the order to unfreeze the funds? And second, if this case does return to the Supreme Court, will that court recognize that only Congress has the power to pass laws and appropriate funds? Or will the court instead allow the president to unilaterally overrule Congress's spending decisions? And the Trump administration's track record in this case, repeatedly ignoring Judge Ali's orders, should raise some major red flags. And the Supreme Court's choice to issue a ruling at all in this matter should probably raise some yellow ones, because as noted earlier, TROs are usually unappealable. Now, it could have been worse, of course, if the court had outright said that TROs are now appealable for the Trump administration, or if a fifth justice had agreed with Justice Alito's blistering analysis. It could have been worse might be the best that we can hope for in the current moment. But I'd argue this decision is not a cause for celebration, because there were 4 justices in the dissent who said outright that they didn't think that any court has jurisdiction over the case because the government has sovereign immunity, even when the government fails to pay out on billions of dollars of contracts. That signals that those 4 justices are likely to allow the Trump administration to get away with even more legally dubious actions, because those justices believe strongly in executive power, perhaps absolute executive power, and think that the job of the court isn't to restrain an out-of-control monarchical president. It's hard to overstate how important this is. If the court says that sovereign immunity prevents anyone from suing over the executive's refusal to honor congressionally appropriated funds, then Congress can pass whatever laws it wants to, but the executive can just refuse to enforce those laws. And it only takes 4 justices to grant certiorari on a case, to allow a case to be heard in the Supreme Court, which Justice Alito clearly invited the defendants to ask for here when he stated that the majority should, quote, at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. But for now, the case has returned to Judge Ali in the DC District Court. On March 6, Judge Ali held a status conference for the parties. The parties each reiterated their arguments, and the plaintiffs pointed out the extent and cost of the defendants' noncompliance with the court's order, including the government's apparent invention of new bureaucratic hurdles to obtain the promised funds. Plaintiffs argue that defendants' own declarations make it clear the administration has added new layers of bureaucracy to prevent the review process, requiring political appointees to sign off on each individual payment and confirm that the payment isn't only valid, but is also in line with the president's policy priorities. Plaintiffs also argue that despite the court's order to halt stop work orders, the defendants have continued to terminate contracts en masse. Some contracts have been reinstated, but the process and guidelines for reinstatement are predictably chaotic and disorganized. Plaintiffs laid out a proposed schedule for the government to pay out on its contractual obligations. Defendants claim that they are actually already in compliance with the court orders. They argued that they had continued to individually assess contracts and that no contracts are in a paused state because they have all either been retained or terminated. Defendants assured the court that they had reviewed the plaintiffs' contracts and are in the process of making payments to plaintiffs, and they argued that therefore the plaintiffs' challenge to the executive order's pause on payments is now moot. But the plaintiffs disputed the assertion that the payments owed to them have been satisfied, and the court has yet to rule on these warring factual accounts. But it's very likely that if the court rules that the government's actions still haven't fulfilled their obligations, there will be a speedy appeal by the Trump administration, which will eventually end up back at the Supreme Court where, best case scenario for the plaintiffs and possibly democracy, a razor-thin majority will uphold the requirement that the United States make good on paying its debts. And at the scheduled hearing, Judge Ali apparently ordered the government to pay up by Monday at 6 p.m., which might be the day that you're watching this. So I also look forward to finding out what the government does just as much as you do. And at the same time this happened, hundreds of diplomats joined together in a letter to Marco Rubio protesting the dismantling of USAID. And when you look at the headlines, you see very different frames emerge that shape how readers interpret and understand the events that are unfolding. On the right, we see headlines claiming that, quote, we may all regret dismantling USAID, mostly because it undermines US leadership and security. On the center, a common theme is to signal boost the letter's central argument that USAID is, quote, one of the most efficient, effective agencies. And on the left, headlines typically focus on the consequences to those who rely on the aid, like the millions of people suffering in Gaza. And the headlines you read have immense power to shape how you understand the news, which is why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEaglets 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting from across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are unreported by either side of the political spectrum, like the story of the Trump administration considering criminal referrals of USAID employees on fraud charges. This story was a blind spot for left-leaning news media, representing only about 10% of all sources that covered it. It's analysis like this that helps explain why we often talk past each other, and why some people seem hyper-focused on what seems like nonsense or fake news. But that's why ground news is my favorite way to get the news. And as a legal eaglet, you can save 40% off their Ground News Vantage subscription by scanning the code that's on screen right now or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the news media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.